Good afternoon, everybody. Welcome. My name's Karina. I'm the self-service administrator here for the Palm Beach County Clerk and Comptroller's office. And today we're going to have a workshop on residential eviction. I'm going to give you a brief overview of what we're going to cover today. I'm going to briefly tell you about the Clerk and Comptroller's office and the services that we provide. Then we'll talk in general about landlord and tenant rights and responsibilities. Then we'll do an overview of the eviction process. And then I'm going to go step by step on both how to evict a tenant or how to respond to the eviction if you're a tenant. After we go through the procedural steps, then there'll be a time period at the end of the class for any questions that you may have. And I dedicate a pretty good chunk of time to questions, so if you please feel free to save them for the end. If you need to write it down, I give everybody a pen, and then I'm happy to answer any of your questions. And I have some experts here from the clerk's office that can also assist me if it's a particularly tough question. So just to tell you a little bit about the Clerk and Comptroller's office, and I know I have some people who have been to my other workshops, so bear with me. The Clerk and Comptroller is the trustee of the county's public records and public funds, and we provide various services to the community, and one of those services are our self-service centers. At the self-service center, we offer a couple of main services to the community. One of those are our user-friendly form packets. There's a list, a handout that you have that shows all of the packets that we sell at our self-service center. So currently we have 70 packets on everything from eviction to divorce, child support modification. So these are for people who are choosing to represent themselves or can't afford an attorney. And so they're pre-made template forms where you can just fill in the blanks, and also include step-by-step instructions where to file, what forms to file, in what order. So we have those packets available that we regularly update with the new forms. We also have public access computers where you can look up your case and do some research on what's going on as far as the status of your case. And we have attorneys that we contract with that can help you with form completion. These attorneys, because they are working for the clerks, they're not allowed to give you legal advice or be your private attorney as far as representing anyone in court. But they can help you fill out the forms for the packets that we sell so that you can leave the appointment with your forms completed. Their services are $1 a minute in increments of 15 minutes. You can make appointment at our self-service center or by calling us on the phone at the self-service center. And we have these services available at our Palm Beach Gardens Courthouse, Delray, and here in West Palm Beach. And the forms are available at all of our courthouse locations, including Belgrade. And then we have some clerical services, such as we have a notary, and you can obtain copies at the self-service centers as well. The main thing to emphasize is that we can give you procedural information. We can help you in determining some basic questions about what forms you need, but we're not allowed to give anybody legal advice. So sometimes we'll be able to explain to you what your different options are. We just can't tell you which one's best for you. Okay, so we'll get into landlord's rights and responsibilities first. These responsibilities and rights I've taken from Florida statute. And at the end of the presentation, I have a link to the statute. This entire presentation is already online on our website, mypalmbeachclerk.com. But basically, a landlord is responsible for maintaining certain aspects of the rental property. The statute specifies that it includes things like the foundation, outdoor walls, structures, doors, windows. If it's an apartment or a condo, any of the common shared areas. They're also responsible for complying with any codes that the city or the county where the property is located has in place. For apartments or condos, they are responsible for an extermination of pests, but the statute does not specify that they are responsible for that for single-family homes. And maintaining clean and safe common areas. And finally, providing functional water and heat. At all times, even if a tenant is currently behind in their rent, the statute says that you cannot cut off the utilities as a do-it-yourself way to evict the tenant. You would have to commence eviction proceedings with the court and maintain the utilities in place in the meantime. You also can't change the locks prior to having a final judgment of eviction as well. What rights do the landlords have? Well, they have the right to receive full and timely rent from their tenant. They have the right to re-entry And the statute specifies that reentry would be either to make repairs, to inspect the property, or if they're selling the property, to show it to prospective buyers. The law in Florida does specify, however, that you have to give a reasonable amount of notice and enter the property during convenient times. For reasonable notice, it says a minimum 12 hours. And although it doesn't have a specific convenient time, there is a time period suggestion of between 7:30 a.m. and 8 p.m. to give you some guidelines. So your landlord shouldn't be knocking at 1 o'clock in the morning to get into your apartment. And the right to the return of premises without damage other than normal wear and tear. So what are the tenant's rights and responsibilities? Well, the tenant also has the responsibility to maintain the property, as far as they are responsible for safely and reasonably using any appliances, the plumbing, the air conditioning or heating units in the apartment. They are responsible for throwing out garbage and keeping the apartment in a sanitary fashion. And they are responsible for avoiding unreasonably disturbing any neighbors and for paying their rent in full when due. What are some of the rights of tenants laid out in the statute? Well, they have the right to fair treatment, and the statute specifies that means they have the right to be free from retaliation if they complain to the landlord, or if they form a tenant organization and meet, or if they demand any kind of repairs. They should be treated as any other tenant would be treated. They have the right to peaceful use and enjoyment of the property, which the law goes on to specify means that if there's another tenant, if we're in an apartment building situation, that is inhibiting the other tenant's abilities to live peacefully, that it is the landlord's responsibility to take some action to remedy that situation. And they have the right to a habitable residence. And the statute goes on to discuss the basics, such as heat and water, that are required in our jurisdiction.
Excuse me.
Yes, ma'am.
Electric is not required. Only heat and water are required.
Well, the statute says heat and water. That's all it specifies, but it does go into a little bit of detail about the definition of habitability, which would seem to me to include that there be electricity in the home. Landlord-tenant relationship. So talk a little bit about how the landlord-tenant relationship is created. Before we get to an eviction, we have to have some sort of agreement. However, in Florida, in order to have a landlord-tenant relationship for purposes of an eviction, there doesn't have to be a written contract. Florida does acknowledge that sometimes there's verbal agreements for payment of rent and a landlord-tenant relationship, or sometimes the written agreement ends and the parties continue along the same path based on a verbal agreement. So an agreement between a landlord and a tenant usually includes 4 things. A description of what property is being rented, and that doesn't necessarily have to be a detailed description, but the address of where you'll be renting. A designation of who are going to be the tenants, who's going to be living in there, and sometimes it's multiple tenants. How much rent it's going to be due, and the duration of the term of the tenancy. However, in Florida, it's not detrimental if that wasn't discussed. If you are renting something and it's not clear in your verbal or written agreement what the duration of the agreement was going to be, then they'll base it on how frequently you pay rent, right? So if you pay monthly rent, they'll treat it as month to month, and the statute says that you would have to give at least 15 days notice to terminate it outside of an eviction. If somebody pays rent on a quarterly basis, which you would see maybe more for a non-residential, then the statute says 30 days notice, and so on. So the fact that there wasn't any clear agreement as to when the rental agreement would end would not be detrimental in Florida. Now, if you're in a situation where you say, there's somebody living in a property that I own, they're not paying me rent, but I still need to get them out of there. There are other kinds of legal remedies, such as unlawful detainer and ejectment. At the end of the workshop, I will briefly touch on those 2 other areas. Now, each of them could have their own workshop, So I'm not going to go into great detail because we're focusing on eviction today, but I'll give you a general definition of each of them in case you realize, oh, my situation doesn't exactly fit into what we discussed as far as eviction goes today. So how can a landlord or a tenant terminate a rental agreement? Well, one way is that if the tenant abandons or surrenders the property. Another way would be that there was an agreement that the rental period would end at a certain time, and that time period comes. Or eviction, which means that the landlord is seeking to terminate the rental agreement prior to its natural end, either because the tenant is not paying rent or because the tenant is not complying with some other term of the rental agreement. Okay. If you look at the packets that we have for eviction, which I believe are packets 47, 48, and 66, you'll see that we have a packet that is for evicting someone because they didn't pay the rent, but then there's a separate packet for evicting someone for non-compliance with other terms in the rental agreement, because there are some different requirements under the statute as far as how much notice is required to be given to the tenant and so on. And we'll talk about those distinctions as we go through the workshop. Okay, so if you are a landlord and you decide that you need to proceed with an eviction, and once you've determined if it's for failure to pay rent or non-compliance with other terms, sometimes people will say, well, it's both. The tenant isn't paying rent and they're also not complying with all these terms in the rental agreement. And then you'll have to just determine which one that you want to file. And you know, some people, the failure to pay rent, the notice period is shorter, so they go with that one. And then you also need to decide if there are any damages to your property or money owed back rent, if you want to pursue those damages, or if you just want to file an eviction for possession only. In other words, there's paperwork where you're just saying, I just want the person out of the apartment, and then there's paperwork to say, I want the person out and they owe me this amount of money. And this matters to you if you're a landlord or a tenant, because if you're a tenant, there's going to be two different complaints that you have to answer to, and we'll discuss that when we get to the tenant section. So here you can actually file the complaint for an eviction and damages together simultaneously in the same case number, but there is a few additional steps that you have to do if you're requesting damages, and some extra forms that you'll have to fill out as the case goes on, and we'll discuss those additional forms today. But the complaint for eviction, we have one joint complaint for eviction and damages should you choose to request and seek those damages as well. Okay, so just to give you an overview before we go through all the steps of the eviction, the first thing that you have to do, and I'm going to go into more detail for each of these steps in just a second, is you have to give notice to the tenant that you'd like to terminate the rental agreement, and that if they do not comply, that you plan on filing an eviction. And this notice has to be given before you file with the court. And we'll discuss when you need to give a 3-day and when you need to give a 7-day notice, and what the notice needs to look like. Then, once the notice period has expired, there is some paperwork that you need to file with the court to start your case. Then the tenant or tenants need to be served with the court paperwork. After they are served, there is a waiting period, and we will discuss those time periods, where you're going to see if the tenant files any kind of answer with the court or if they default and do nothing. And then there will be a final judgment, which may or may not include a hearing with the judge, depending on what the tenant does. And in some cases, this last step doesn't apply to any cases. In cases where the eviction is granted and the tenant still does not leave the property, sometimes a landlord will need to seek a writ of possession, which we'll discuss in more detail, but is basically getting the assistance of the sheriff to remove the tenant from the premises. So, step 1, notice from the landlord to the tenant. You give this before you file any paperwork with the court. As a matter of fact, when you file the paperwork with the court, you have to attach proof of that notice that you gave to the tenant. And if you're trying to evict someone for failure to pay the rent, or if you're being evicted for failure to pay the rent, what is required is a 3-day notice, and that is 3 court days. That does not include Saturdays, Sundays, or holidays, so 3 business days. And if you're trying to evict someone because they are not complying with some other term in the rental agreement, then you have to give them a 7-day notice, but that is calendar days, so it does include weekends. Now, the statute in Florida is very specific as to what has to be said in that notice. So you can look at the statute and create your own, or if you purchase our packets, we have pre-made notice that has all the language from the statutes, I believe taken from the Florida Bar, that's already in there that you can just use and fill in the blanks. But the statute does have the language that is required to be included in any notice that you give to your tenants. And this notice can be posted, hand-delivered, or mailed to the tenant. So oftentimes you see what you hear about is that it gets posted on the door of the rental property. If you're a tenant and you receive such a notice on your door in the mail or hand-delivered, you have a few options as to what you can do at that point. You can pay your rent in full if you're able to do that. If you can only make a partial payment, Florida law does allow the landlord to refuse a partial payment. They can continue on with the eviction and not take the payment. If a landlord takes a partial payment, then they would have to then post a new 3-day notice with the remaining balance. So the clock would start ticking again. They can't just take it on the 2nd day and then on the 4th day come and file an eviction. So you would have to do a new 3-day notice that would subtract the amount that you accepted from the tenant and repost it, and the period for the notice before you can file an eviction would restart. Okay? Or the landlord can reject it and proceed with the eviction. As the tenant, you can vacate the property. That's another option that you can do prior to any eviction being filed. Or you can do nothing, but if you do nothing, then the landlord can proceed and come to court and start that eviction case. So once the notice period has ended, if the tenant has not complied, the landlord may come to court and file for eviction. And these are the basic forms. And if you purchase one of our packets, these forms are already in there. But if you're doing it on your own, you would need to file a county civil cover sheet, a complaint for eviction, or if you're seeking damages, a complaint for eviction and damages. You would need to attach a copy of that notice to your complaint. You can also attach a copy of the lease, but I believe that's not required. But if it's a case for non-compliance with the term of the lease, that may be helpful to the court. And then there are some filing fees that you would have to pay at the time that you initiate your case. An eviction costs $185. There is a $10 summons fee per tenant. So if there's multiple tenants, you may have to pay more than $10. Also, if you are suing for both possession of the property and damages, there's going to be 2 summons issued, because as we'll discuss in a minute, the tenant has 2 different time periods. They have to respond to your eviction for possession relatively quickly, but they get additional time to respond to a landlord's request for damages. So they're going to issue 2 different summons that have 2 different time periods as far as what the tenant needs to do. Therefore, even if you had 1 tenant, you would need 2 summons if you were suing for both damages and possession. Yes, ma'am.
I had a question about the previous slide. When it said the person can just leave the property, would that stop the eviction process? Could it?
Well, it depends. It depends. If they vacated the property and all you were asking for was possession, then your goal would be accomplished. But that doesn't mean that the landlord could not sue the tenant that vacated for damages if there was money owed. Although, you know, I'm not sure, and at the end we'll have a question and answer session, and I would like to inquire as to whether you would have to dismiss the eviction and then sue them for in the small claims or something, or if you could proceed with the eviction if they're no longer in the property. Right. But I'm going to tack that question and we'll address it at the end during the Q&A session. Okay, so once you file that list of papers that I mentioned, you have to have the tenant served. And there's a couple ways you can do that. You can do it through the Palm Beach County Sheriff's Office, and that costs $40. And if you do it through the Palm Beach County Sheriff's Office, and when you come file, you provide the payment to the Sheriff's Office for the $40 to us, then we can forward the paperwork and the fee to the Sheriff's Office for service for you. Okay? Or you can choose to hire a private process server. If you do so, they need to be certified. At the end of this presentation, I'll have the website for the court, the 15th Judicial Circuit, that has a link to a list of certified process servers in Palm Beach County. Their fees vary because they're private businesses, so you would have to inquire with them as to what the fee would be. Now, I'm making a note that an action for damages must be personally served because Florida law actually says that if you're just trying to evict someone for possession of the property, they don't have to be personally served. It can be posted on their door, and that would be adequate service. But if you are asking for money damages, then they have to be personally served. So there is that distinction. If you choose to do eviction and damages, they'll know that they'll have to be served in person, as opposed to just possession, where posting, the sheriff can post on the door. Okay. For purposes of, yes, ma'am.
I'm sorry.
No,
I know you said we had to submit a summons for each tenant. So is that the same for when serving them? Does each tenant have to be served?
That is correct. If you're seeking damages from each tenant, then each tenant would have to be personally served. If the multiple tenants reside in the same place and you're just seeking possession, there still need to be a summons for each tenant, but you could post them all on the door. Yeah. Okay, so if you're a tenant, or you're helping a tenant and they've been served with a complaint for eviction, this is the time frame that they need to think about. And the key here is that it's a very quick process. In Florida, eviction process is very streamlined and it's quick. So you don't have a lot of time as a tenant to file a response. If it's seeking even if it's a eviction for damages and possession, they're going to kind of bifurcate this part of it. And if you're going to file an answer in response to being evicted for possession purposes, you only have 5 court dates from the date you were served to file that answer with the court. Okay? You have 20 days to respond to any complaint for damages, so you could just deal with the possession first and then answer the damages section later on because you have some extra time, and that may allow you to speak to someone, get some legal assistance. But for the eviction portion, you only have the 5 days. There's no pre-made form that you have to use for an answer. Okay, you can create something. We just have a generic answer template, and you could get at the self-service center for $1 that has like the court caption information, petitioner, respondent, with just lines that you could write it. But you want to make sure that in your answer you either admit, deny, or say you do not know the answer to anything that is alleged in the complaint. There's an additional requirement, and it's a very important requirement, if this is an eviction for failure to pay rent. And that is that the Florida law requires that the amount of rent that the landlord is alleging is due must be paid into the court depository. So the court has a depository where they hold the money pending the case. Within the 5 days that you have to answer. So in addition to answering, you'll have to pay the money that is due within those 5 days for it to be a complete answer. If you don't pay the money alleged into the depository, then the judge could treat it as if you didn't answer and allow the landlord to proceed by default. The only thing that assures that the judge will give you a hearing is if you put the money into the depository. This is different, obviously, than if it's a case for eviction for any other reason, then an answer would suffice. But if it's for failure to pay rent, the law requires that you pay the alleged sum into the depository. The only exception that the statute says is if your defense in your answer is that I did pay the full amount, and you attach the proof that you paid the amount, then you wouldn't have to put the money into the depository. But any other defense, it's required that that money be in the depository for the court to consider it a complete answer. Okay. Once the time period has ended, what happens next depends on whether the tenant files an answer or not. Okay. If the tenant files an answer and, if applicable, pays the money into the depository, then the judge is going to review the case, and they'll determine if a hearing is needed. And if a hearing is set, the court will notify all the parties by mail, the landlord and the tenants, of the hearing. And then the parties show up to the hearing, and present their case to the judge. If you are a landlord, you will want to bring a proposed final judgment with you to the hearing for the judge to sign off on. Every judge is different, but most of the judges lately have been wanting parties to provide their own completed judgment. And the packet also includes a template for that as well. If you're a tenant, then you're going to want to bring any evidence or proof that you want the judge to consider to your hearing, because this is probably going to be your only shot. Okay. Now, if you're seeking possession and their tenant does not file an answer or does not pay any unpaid rent into the registry, then a landlord can request what's called a default judgment. That means they're going to ask the court to proceed without the tenant and finalize the case after those 5 days are complete. There's some additional forms that as a landlord you would have to file to ask the court to proceed by default, and these are the forms that you would need. You would need to file a non-military affidavit. This form tells the court that you as a landlord do not believe that the tenant is an active member of the U.S. military, because that would be a valid reason maybe why they would not be responding within the 5 days. The easiest way to satisfy this requirement is to print out what's called a status report provided by the Department of Defense and attach it to the non-military affidavit. And this website that is live, if you go on our website to this presentation, will give you, if you have enough information about the tenant, it'll print out a status report that either says, we searched all the branches of the military and this person is not in the military, or yes, they are in the military, that you can attach to your affidavit of non-military affidavit. You'll have to file a motion for clerk's default for residential eviction, a motion for a default final judgment for residential eviction, and then a proposed final judgment, which, because you're asking to proceed by default and the tenant didn't answer, there's not going to be a hearing. So you will provide 2 self-addressed stamped envelopes, one for you and one for the tenant, that the court will mail the final judgment to the parties. Now, if you requested at the beginning both possession and damages, after the 5 days, you can only proceed with the default for the possession, because they get those 20 days to respond to your request for the money. After the 20 days have passed, if the tenant still has not filed any kind of answer with the court, then you can also ask to proceed by default for your damages claim. And that would require a second set of default paperwork, okay? So you would have to file a motion for clerk's default for damages and a motion for default final judgment for damages. There's also an additional form which is called an affidavit of damages, where you kind of have to lay out to the judge where you came up with the number that you're claiming that the person owes you, if it's just rent or if it's damage to property, etc. And also a proposed final judgment for the damages with those 2 stamped envelopes once again. And the court will mail the parties the final judgment. So this final step that doesn't apply necessarily in every case is the writ of possession. If an eviction is granted and the final judgment is entered and the tenant still does not vacate the property, the landlord may apply with the court to get what's called a writ of possession. And a writ of possession is basically an order that instructs the sheriff to remove the tenant from the property. The sheriff charges $90 for this service. You can come here to the courthouse, the same place where you filed your eviction, and request the writ of possession. And once you have the writ and you deliver it to the sheriff, they will first post a notice on the property giving the tenant an additional 24 hours to vacate on their own. After that, then the sheriff can accompany the landlord to the property if the landlord wants to change the locks or otherwise assist with removing the tenant from the property. So from the landlord's perspective, that would be the last step that you would need to regain possession of your property. If you're coming from the tenant's perspective, the key is that you want to file something with the court before it gets to this point, because now you only have 24 hours, and the chances that you could get before a judge in 24 hours is very slim. So I mentioned briefly at the beginning that there are some other eviction-related kind of cases that you may fit into if you're not receiving regular rent from, or there was never an agreement for payment of rent. from the person that you're trying to get out of your property. And those are mainly unlawful detainer and ejectment. And I'm not going to go into too much detail. Like I mentioned, they could each have their own workshop, but I just wanted to touch upon them because I do sometimes get someone that sits through the entire workshop and says, no, that's not really my situation, but I just thought it was all called eviction. One of them is unlawful detainer, and that's basically there was never an agreement for the payment of rent, or there was never periodic payment of rent. You gave someone permission to stay with you. You no longer want them to stay with you. They no longer have your consent, and you can't get them to leave. And the main difference between the unlawful detainer and the ejectment is that an unlawful detainer can be brought by a landlord or by a lawful tenant. So someone who's renting can file an unlawful detainer against someone that they allowed to stay in their rental unit and will not leave. You know, a common example of this is you let a friend stay on the couch or a boyfriend or something, and then they won't go. An ejectment is a little trickier, and as I mentioned, we can't give you legal advice. So if you're not 100% sure which one fits best for you, we would recommend that you seek legal advice from an attorney. But an ejectment is more competing claims of ownership or title, okay? It needs to be brought by someone who owns the property. It can't be brought by a tenant. And basically, this is someone that you don't have a landlord-tenant relationship with, but they're claiming that they have a legal right to the property, either to own it or to possess it. And you're claiming that you have the legal right to the property. So there's two competing claims that the judge will have to determine who actually has a legal right to the property. Ejectments are not as common. You sometimes see them in like foreclosure sale situations, or when somebody is passed away and there's competing estate claims. That's mostly when you will see an ejectment. So we have packets for each of these also at the self-service center if that's the situation that you find yourself in. One last slide and then I'm going to come to you, okay? We're almost done. So if you go to our website, in addition to being able to read this PowerPoint presentation and soon watch the video, we have a toolbox under the Landlord Tenant Workshop section, which has a lot of helpful information that can go in way more detail than I can in this workshop. It has a link to the statutes that I've been referencing regarding landlord tenant eviction. It has some brochures on landlord tenant law from the Department of Agriculture, from the Florida Bar, from a website called Florida Law Help that just has a lot of general information for people representing themselves. It has a link to some homeless veterans resources, to legal aid, Florida Rural Legal Services, and the Palm Beach County Department of Community Services. So there's a lot of information that goes into much greater depth on both the landlord and the tenant side, and that's all available under our, we have a do-it-yourself workshop page in the self-service center section of our website. You can see all this information as well as any other workshop. So these workshops rotate every month. So you can, there's workshops on divorce, how to collect a money judgment, and many different topics that are all available on that page. And then finally, there's some helpful links. Our website, which under our county civil section has information on eviction. Also, you can find the self-service section to get all the information from this workshop. There's a link to legal aid and Florida Rural Legal Services, which, and we may have some people in the audience from those organizations, but they provide tenant assistance. They have their own rules for who they can accept. They have only so many attorneys, so I wouldn't be able to guarantee anyone that they would be able to assist, but I do know that they both have landlord-tenant clinics where they do provide assistance to some tenants. So if you find yourself in that situation, you may want to contact them to see if you're eligible. And then a link to the 15th Judicial Circuit, that's the court's website. In addition to having the information about all the judges assigned to county civil for eviction, it has the list of those certified process servers if you find yourself in the situation where you need to hire a private process server instead of the sheriff. Thank you for your patience. And now, I know there's already one question waiting, and then I'll come to you, sir. Yes, ma'am.
I know you mentioned you didn't want to go into any thorough details regarding unlawful claims.
Yes.
And ejectment, but I had the one question about, you said it could be brought on by either a landlord or a lawful tenant. What's considered a lawful?
A lawful tenant means you're not being evicted. You're paying the rent, and you're part of the lease. So if you're on the lease and the landlord considers you a tenant, you can bring the unlawful detainer. You don't need to have the landlord do it for you. But if you're someone that's staying with the person and the landlord doesn't believe that you have a landlord-tenant agreement with them, then you perhaps would not be able to bring that action, is what I mean. Yeah. This gentleman right here, and then you say yes.
The packets that you mentioned?
Yes.
Where, do we get them from that website?
Oh yes, I'm sorry, that was at the beginning of the presentation, but I'll repeat it. No, right now those packets are not available on our website because we're not set up at the moment to take payments through our website. They're available at any of our self-service centers. There's one more way to get it. So here in West Palm Beach, we're temporarily, while we're getting renovated, on the 3rd floor, room 3.21. You can purchase it there. Del Rey, on the 1st floor, we have a self-service center, as well as Palm Beach Gardens and Belle Glade. You would just go to the civil clerk's filing window and you could purchase any of the packets there. Or you can request it by mail. If you write to our self-service P.O. box, we will mail it to you. There's just an additional fee. For the eviction packets, it's $3.50 for the shipping and handling. Yes, sir, and then I'll come to you, ma'am.
My case is a little bit different. I had a tenant, quit paying rent, and they moved out at
Okay.
some point in time, which I don't know because I'm from out of state.
Okay,
Okay, and in the process, they were selling stuff on eBay. Now my lot is a landfill, and my house is a landfill, and my appliances are gone, so apparently they found buyers for my appliances
Oh,
and
boy.
stuff like that.
okay,
Now, I spoke to an attorney about it, and she told me that basically, this is what she told me, she says, your property has been abandoned for more than 15 days. And I did send, I have her, the tenant's email, of the wife. I never had the husband's, but I had the wife's. And so I sent her a notice that I was changing the locks. You gotta give a 12-hour notice, I guess. So I did that, and I also put up on the door, you know, unpaid rent. And so, kind of my question is, if I don't go through the first process of the sheriff, okay, how would I go through the second process of trying to reclaim damages?
Okay.
Lost rent, and so on and so forth, because they're not there anymore, and I don't know where they are for sure.
right. Well, I see two different questions here. One is, if they've abandoned the property, do you still have to evict them? And the second one is, if you don't, how can you go after the money that they owe you now for your property
Yeah.
that they sold? Can you?
They evicted themselves by leaving.
Right, so let's say that you didn't have to evict them, that they meet all the statutory requirements for abandonment. And I guess this also goes back to my question, I mean, you can sue them in court, depending on how much they owe you. So if the amount of damages that you're claiming is $5,000 or less, you could sue them in small claims, file small claims action. If it's between $5,001 and $15,000, you could file a county civil court suit against them. And if it's more than $15,000, you would file a circuit civil. But you can absolutely sue them for damages. It's just you're going to have some difficulties in that the court can't assist you and the clerk's office can't assist you in locating the parties. So that's going to be your hiccup. But can you sue them? Absolutely. It's just, it may be hard.
Do I have to use that packet too to do that, or would this be like just?
No, we have a separate package for small claims action, if it's $5,000 or less, that you could purchase.
Okay.
If you're going to file any kind of civil suit for more than $5,000, there aren't any pre-made forms, so you'd have to create them yourself. But online you can find templates of pleadings, or if you go to the law library, they have a generic complaint pleading that they sell that has instructions. It's a packet that's just generic for any kind of civil lawsuit that isn't one where there's pre-made forms. And then the law library is located right here on the 1st floor of the
Okay,
courthouse.
so the small claims would be one way, under 5,000.
Correct, 5,000 or less.
Okay,
And there are pre-made packet forms for that.
and I presume the small claims court does not include the filing fees? There's got to be filing fees, right?
There are filing fees in small claims court, but you can seek cost from the court I believe, yes. You can ask the judge to include the cost in the damages.
Do that for-
And even attorney's fees if required. And in any civil action, you can request that.
And the small claims was one, and the other one would be,
You would just have to file a civil lawsuit, either in county or circuit civil court, depending on the damages. County goes up to 15,000.
okay,
Circuit court is for anything more than 15,000.
okay.
Yes, ma'am.
I have
I
a
get it.
tenant that is in an apartment, but she's indisposed right now. And so we went in and we secured the apartment, but we noticed the window in the back was broken. And there was men's boots, which there isn't, it's only a one-bedroom, it's rented to one female. So we replaced the window, secured the apartment, and then a week later, the window was broken again, and the front door is unlocked. Did a police report, and so it's been 3 weeks, and we've replaced the window 3 times, and continues to break in. We've called the police, and the police says that because there's men's things in the apartment, that we have to formally evict the man because he has property in the apartment. But we don't know the man's name, and they're assuming that it's her boyfriend, who we don't know who it is, and we're not assuming anything. So what happens? Because
So I can't give you legal advice, right?
Right,
Because
right.
this sounds like a question that would elicit legal advice from an attorney. But you haven't actually seen a person there. You've just seen boots, is what you're saying.
Right,
But
and
you,
a broken
but
window
but
and
when you say the
unlocked.
tenant is undisposed, you mean she's out of the apartment and she made that known to you?
Well, she's detained,
Okay,
so she's
right,
in jail.
right. I can't give you advice. In other
So
words,
if we wanted to file eviction without a
well,
name.
he's not your tenant, so I don't
Right.
think that you can evict him because he's not your tenant.
So is there squatter,
It's a
like I
form of
hear about
trespassing.
squatting?
There are laws and rules about squatting, and it may be that you fit better into one of those other situations. I'm not sure, just based on boots, that I know what the relationship of this person is to your tenant and what, if any, rights they have. They may not have rights, and they may have rights. I don't know if they're married to your tenant. So it's hard for me, based on what you're telling me, to give you any information. And to do so, I would probably have to give you some advice as to what I
So
thought.
Even with the broken window, it's, you know.
I mean, it sounds like somebody's trespassing on your
Yeah.
property, but I'm not sure of all the facts, so. Sorry.
Ejection?
Well, ejectment would be if that person claimed they had a legal right to the property, which I don't think they do. Unlawful detainer, someone who had consent and no longer has it. I don't think she ever gave this person any consent. So it doesn't neatly fit into any of the categories, which is why I would probably talk to a private attorney. Yeah.
I put up surveillance.
Well, but you're getting advice from the audience. It's gonna.
And you have it monitored, and the minute the guy gets in there, you call the police, 911.
He can give advice, but I'd like to clarify that this gentleman does not work for the clerk's office.
No, really.
Yes, sir, and then you, ma'am. Yeah.
On the original 3-day notice, if you have other fees that are owed, whether it's like late fees or
Yes.
things that they owe you, can you put that in the amount, or is it strictly just the rent?
You can put late fees in the amount if it's specified in the rental contract. It has to be something that they knew of in advance, that if they didn't pay the rent on time, they would be responsible for it. So as long as it's something in the rental agreement that the tenant signed, then yes.
Right. And if the building itself's under a corporation, you could file as the individual, or
As the individual landlord,
as a managed member, or whatever your position is,
if you own that particular unit, then you can file for eviction.
as an individual. And so you would fill out the corporate name, or
Does the corporation own the unit, or you, do you know the answer to that question, Ralph? Like if a property management company owns it, who can evict the tenant?
It's popular because of the company.
One second. Yeah,
It's kind of like a tricky,
yeah.
situation. There's a possibility I've seen it happen where the judge will grant you possession, and there's times where the judge said, oops, sorry, can't do it. You have to file under the corporation because that's,
Or if the corporation has a registered agent,
right.
that individual
So,
could.
I mean, the situations vary, and sometimes even an attorney might be required depending on the situation. So it can be a little iffy, and it's something that unfortunately we can't get into because there's so much more involved.
The action has to be filed under the name of whose ownership of the property is.
So if an LLC owns it.
Right,
the
but-
LLC has to do it.
But there's, for example, there's a form that you, as a business, as an LLC, you can designate an employee or a registered agent to represent you at this proceeding on their behalf.
In Miami-Dade, you have, if you're a corporation, you have
Yeah.
an attorney represent you as an individual, even if you're a...
That's the file an answer.
Sorry, that's me.
That's okay. As a petitioning landlord, I do not believe that's the case, that you have to have an attorney representing you. But if, you know, like she said, judges have a bit of discretion sometimes on how they handle it here in Palm Beach County.
Every situation is looked at differently, and of course a judge will look at, you know, it's going to try to go based on what the law, you know, requires and stuff like that. So at times what might work for one person is not going to be the same for another because something else came into play that maybe, you know, for example, myself as clerk, I don't know if maybe something was presented in court and stuff like that. So every situation ends up being different. And like I mentioned, there's times where you might be required to have an attorney. The judge doesn't agree that this person can represent you for whatever reason, and the case will not move forward without an attorney.
But I do,
Different scenarios.
but I do know for a fact, because we have that form in our packets and in our small claims packets as well, that in Palm Beach County, a corporation can designate an employee to represent them at the hearing, not a non-attorney, just to be the representative of the corporation. That's not the registered agent.
Would that include a property manager? That's kind of-
As long as the corporation designates that person and files that form, the judge can consider it. Yes, ma'am.
I technically have 3 quick questions. One is, I have trust with my father. We own more than 30 properties. We're on the Western communities. I've been doing this a long time. Never had a problem. Unfortunately, this last instance that I did count 1 and 2. So you do for eviction and then for damages.
Yes.
The damages were more than $15,000, and I forgot to read the fine print. And I put it for $17,000, and it got denied.
Right.
So what to do? Do I make it $14,999 to stay under that?
Well, I can tell you your 2 options. I can't tell you what's better. You either make it $14,999 or you file an eviction and a separate action in circuit civil court.
They're out.
Right, then you could, you could file a separate civil action in circuit civil, right? Or you can decide to accept less.
$14,999.
Yeah, that's up to you, but that would keep it in
Okay, so
county
now
civil.
there. Secondly, why for the Western communities is everything out of Belle Glade?
For the west communities?
On Wellington, Royal Palm.
Right. I think it's just, I don't know about
I didn't know
the,
that, so like if you're trying to like do a speedy thing, you basically have to drive it out there, because if I bring it here, then I have to get a courier. I mean, not I have to, you courier it out, and that's another 3 or 4 day lag.
I'm gonna ask our manager here.
The branch designation or branch assignments for county civil is actually designated by administrative order. If there's an AO out there that lists like all of the zip codes in Palm Beach County. A couple years ago, they transferred some of the Wellington zip codes.
It's Wellington and Royal Palm.
Yeah.
That's where I'm from.
Out to Belle Glade.
Yeah.
And it's all based on that administrative order.
Okay, and then my third thing is, what would you suggest, since now I've been denied twice on my judgment for damages, what are documents that I need to attach? I've never been denied any of them. I'm not a novice to this. I mean, my family been managing properties for 30 years.
I can't suggest anything because that would be giving you legal advice, which I'm not allowed to do.
This is my 3rd attempt to try to get this judgment for damages. I understand I made the mistake the first thing, so I forgot to do it over 15.
Right, so that may be the, like I said, I can't give you advice on how to present your case, but that may be the only issue. Once you change that, it may go forward just like your other ones. But I can't, because that would require me to give you a strategy on how to present your case, and I'm not allowed to do so.
Okay.
So attorney for the clerk's office, I apologize. Yes, ma'am.
Lawful tenants.
Yes.
Because you don't always know their names.
Yes.
And you don't have to serve them. Or do you? You don't know.
You have to serve them at least by posting it on the door of the apartment. Correct. So if they're,
You don't know how many people are living there even.
Right, well, so my understanding is that for the eviction purposes, you would just have to list people who are tenants, not just people who are come and go. Yeah, you could do John Doe, Jane Doe, yeah.
It's on the form. It's,
Yeah.
it'll give you the name, you put in the names, and then they have, at least on the form I got for like the 3-day eviction,
Just always
and they have to
have
add it as unknown persons. So,
Yeah. Thank you. Yes, ma'am.
There was just, I just started filing evictions, a couple of months ago because this was all new to me. And I just wanted to add that when we do the $40 PBSO money order.
Yes.
And they go out to file, to serve.
Correct.
The notice, if they don't personally hand the notice to the tenant, then we have to do the envelope, come back with a self-addressed, like an addressed envelope
For them to follow up by mail.
for us to follow up by mail, but we have to hand the envelope to the court, to the office, so that they can mail it.
I'm not understanding, I'm sorry.
We have to bring an envelope.
To the court?
To the tenant with the stamp, with the paperwork in the envelope, and hand it to the office so they can mail it.
Do you mean the sheriff's office?
No.
The clerk's office?
Yes, the clerk's office.
There's a specific requirement that involves posting. So you come in, you file your complaint, you get a summons, and the sheriff goes out and they post. There's a specific requirement in Florida statute that requires the clerk to mail the summons and copy of the complaint to the tenant in that specific situation where they serve the tenant by posting. And you won't be able to get a default, you won't be able to get a default judgment until that is mailed. It's just a provision in statute.
Right.
And we need the copies and the self-addressed stamped envelope to meet the requirements.
Right, so that's not discussed in any of the steps. So I just wanted to mention that because
So this is-
it's not in any of the steps,
It's in the
it's not
packet.
in any of the paperwork.
It's in the
not-
packet though.
Okay, well, just to clarify though, because I'm always happy to add things to the workshop. This is a requirement that when you're electing sheriff service, is that what it is?
No, any service by posting of the
Yes.
tenant, the statute requires mailing and we put a certificate in the file.
If it's not hand delivered,
If it's not served in person, then even if it's posted on the door, it also needs to be mailed.
Especially
Okay.
if it's posted on the door, it has to be.
Well, that is, she's correct, it is in our packet instructions, but I will add it to the workshop. Thank
I
you.
will tell you, many folks who do many of these evictions give us the self-addressed envelope and a copy of the complaint when you file the case, just to cover yourselves.
I just learned in my briefcase to carry a big book of stamps and a bunch of
Yes.
blank
The first
envelopes.
time we did it, John, when you go to the first floor, they will pry that, I don't know.
At the self-service center, we sell stamped envelopes for $1, just in case you ever find yourself
I
stuck.
called the number, I thought I had it.
Any other questions? Yes, ma'am.
We were going to go back to the tenant vacating the property during the
Yes,
process.
so if the tenant, this is my question as well, if the tenant vacates the property in the middle of an eviction, but you were also seeking damages, do you proceed with that case, or do you have to dismiss the eviction and open a separate case for those damages? I think you could proceed on the damages counts, because technically it's two different summons, two different actions. So they'll just dismiss one for possession and continue with two for damages, is my understanding, that you wouldn't have to file a brand new case.
Many folks in practice, they will continue to get the
Right, to get
judgment.
it still.
They'll get the judgment for possession, and then.
Oh, even for possession, okay.
You won't need a writ of possession. That step you'll just omit because the tenants that they needed.
So you would continue on with the process as usual, but then of course by the time writ of possession arrives, you don't need to do that, you just simply report
Exactly.
that the properties were vacated.
Once you get your final judgment for possession, then you wait the additional days and then proceed for damages.
Technically, it saves you money.
Yes, ma'am.
I have a question about the security deposit. I'm actually in the stage, I just filed my writ of possession, so hopefully my tenant will be out. And I'm waiting the 20 days before I file that second part for damage.
Yes.
What she was talking about. So I'm hopefully waiting for her to leave, because then I can file all the damages together on the affidavit. But as far as the security deposit, I want to withhold that too. Is that, after I file all the damages, what,
Well,
do I still need to withhold that security deposit?
There are some additional requirements if you choose to withhold the security deposit under the statute. You have to give notice to the tenant,
Right.
even if they've already been served with a complaint for damages, that you intend to withhold all or part of the security deposit. You have 15 days from when they vacate to do that. And there's certain language that the statute requires, and actually in the packet we have a notice of intent to withhold the security deposit that you can use.
But I guess if I'm going after the damages.
Right, well, that would go.
That total amount, do I deduct the month security, or?
Well, you're going to have to do an affidavit of damages to the judge where you explain where you got to that number. So if the security deposit meets some of what you're requesting, then it would likely get subtracted from the total.
Put it in there, but then I go forward with this, okay.
Yes, sir.
Kind of two questions. One, when I changed the locks, an attorney told me that I've now taken possession. I sent an email to the individual that was the tenant, and she never responded to get keys. Because I said, if you want keys, send me your address and your phone number. And of course, I don't think they want to do that. But my question would be, like, if somebody breaks in now and I've changed the locks, how would that fall? Because they're not a tenant, but they were someone that the other person knew. So they were never on the lease.
That is a very particular question. The reason I'm not sure how to answer your question is because you didn't go through the eviction process through the courts. This person, you believe, abandoned the property, right? You consulted with an attorney and you changed the locks. And you never went through the court. So I'm not sure how you would handle it. I'm assuming if somebody's breaking into the apartment that's not that former tenant, that would be trespassing and you could call the police. But I can't advise you on how to particularly deal with that situation.
What if it was a former tenant, though? If they try to enter after you've already changed the locks?
If you call the sheriff, I could imagine that they may tell you that you need to file an eviction because you never did.
That's what they do.
Yes.
My other question would be is, if you wanted to get some of these laws changed, because I'm going to tell you, my place looks like a junkyard, and it's uninhabitable unless you want to live on garbage. I mean, they got garbage in the house, they're 2 feet high. My sunroom has garbage 5 feet high.
If you wanted to get laws changed, you would have to contact your legislature.
Which ones? County?
These are Florida statutes, so these are state statutes that I'm discussing.
So we're talking about state representative, senator?
Yes.
Okay. 'Cause, I mean, it's disgusting that you have to go through some of this. I mean, if the damage is kind of like reasonable, like just, they got kids and they're breaking
Right.
door.
I understand. Your situation exceeds normal wear and tear.
I mean, I got a steel door that they kicked in.
Any other questions? Yes, ma'am.
Okay, so after your judgment,
Yes.
today I found out that the judgment is automatically recorded, but this brochure says, how can I collect my judgment? It says, record the certified copy in the county, but it's
Well,
automatically.
So in collecting a judgment, it's a different kind of recording. So the judgment is automatically recorded as an official court record. But let's say you get a judgment for damages and, for $10,000. And years later, you find out that the person owns some other property or some personal property that you may want to levy or do something to collect the judgment owed to you. If it's real estate, you would have to record your judgment against the property that they own. So you'd go to the county where the deed for that property was recorded and record your money judgment against that deed. So if the property was ever sold and they go through the creditors, you would be one of them. It's a different kind of recording. You could also get a judgment lien, which would help you in collecting against any personal property they would have.
If they don't own anything, how do you get your judgment?
If they don't own anything, then it's very difficult to collect your money. The court gives you the judgment, but they don't help you collect it, unfortunately. So if someone doesn't own any personal property or any real property, the only other available remedy would be garnishment of wages or bank accounts, but that does require some legwork on your part to find out that information about the tenant. If they don't work, you would have to know some information about them. We have a separate workshop all about how to collect money judgments, and if I just had one recently in Delray, but it's on our website if you'd like to watch it or read it. It goes into detail about all these options for collecting once you have your judgment. That's the tricky part.
I was going to say regarding that, if later on they come into an inheritance or something, and you have that title against them, you'll get to collect. You get to collect against the inheritance. Or like if they wrote a book and all of a sudden started getting money,
Yeah.
you'll be on the list to get your money. But if you never
If
file
I'm already
for
on
it,
the list because it's filed, or I have to file,
well, you have to file the case and try and get it. And if you don't get it at the time, and then later on they come into money,
So there's some additional steps. Just your judgment being recorded as the case was finalized would not guarantee you a spot in line.
Get a collections person or something.
Or just apply for a judgment lien. There are pre-made forms, and the workshop goes into detail on
Oh, there's
it.
a form for judgment.
There is. Any other questions? Yes,
I
sir.
have a comment on something that you put up on one of the slides.
Yes.
As a cautionary tale to
Yes.
landlords. If you set up for the tenant to be able to pay rent through direct deposit into a bank account,
Yes.
facilitate everything, like a lot of people do, and they pay partial rent while you're trying to evict them for not paying rent for a period of time, it starts the clock over again.
Correct. You'd have to do a new 3-day notice.
And it's really hard to stop the payment from hitting the bank because the banks are computerized and they don't have any systems to do
Right.
that.
So even if they put $10 in there.
Right, so even though it helps, everyone uses electronic transfer of funds and all that, this is one case where it's a detriment to a landlord.
I see. That's a good point. Yeah. Well, thank you everybody for coming. I do have these evaluations on the table. If you don't mind filling them out with any feedback and your thoughts on the workshop, I'd really appreciate it. You can just leave them there on the table. I'll pick them up on your way out. Thank you so much.